Hey everybody, welcome back. Okay, so we're going to do 30 more questions. Let's get into them right away. Question number 1. What did the U.S. Supreme Court decide regarding the interpretation of sex in the Fair Housing Act in 2020? Letter A. It does not include gender identity or sexual orientation. Letter B. It includes only gender identity. Letter C. It includes only sexual orientation. Letter D. It includes both gender identity and sexual orientation. Question number 1. What did the U.S. Supreme Court decide regarding the interpretation of sex in the Fair Housing Act in 2020? And the answer is letter D. It includes both gender identity and sexual orientation. So you want to remember the 7 protected classes with fair housing, and you also want to remember that with sex, we did include gender identity and sexual orientation, both of which many times do show up on real estate examinations, so look out for them and understand the interpretation of what that protected class actually means. And also keep in mind that there's not any more than 7 protected classes. That is always going to be the number that you need to worry about. So 7 protected classes as of today, and then you want to make sure that you understand that sex was further expanded to understanding and interpreting both gender identity and sexual orientation. Question number 2. How many protected classes are there under the Federal Fair Housing Act? Letter A, 5. Letter B, 7. Letter C, 9. Letter D, 10. Question number 2. How many protected classes are there under the Federal Fair Housing Act? And the answer is letter B, 7. Okay, so there are 7 protected classes: race, color, religion, national origin, sex, familial status, and disability. Remember those 7? And remember in the previous question, we looked at the expansion of the interpretation of what certain protected classes were. Question number 3. What are littoral rights associated with in real estate? Letter A, properties abutting moving water. Letter B, properties abutting non-moving bodies of water. Letter C, properties with oil and or mineral rights. Letter D, none of the above. Question number 3, what are littoral rights associated with in real estate? And the answer is letter B, properties abutting non-moving bodies of water. So remember, L for littoral, think of the O in littoral for oceans, L for Great Lakes. Think of littoral rights dealing with larger standing bodies of water such as Great Lakes and oceans. So it's a little deceptive, right? Like it says non-moving bodies of water, and all water is moving, right? It's like gravity and stuff. But they want you to understand that there's a distinct difference between riparian rights and littoral rights. And riparian rights would be A, properties abutting moving bodies of water. And littoral rights deal with standing bodies of water or non-moving bodies of water. Question number 4. What is meant by an improvement in real estate? Letter A, an increase in the property's market value. Letter B, the process of renovating an investment property. Letter C, adding value to a property by enhancing its features. Letter D, an increase in the property's assessed value. What is meant by an improvement in real estate? And the answer is letter C, adding value to a property by enhancing its features. Question number 5. Which of the following best describes the principle of anticipation in real estate? Letter A, the financial return from the sale of a property after improvements are made. Letter B, the assessment of a property's value based on expected future benefits and income. Letter C, the price a property is expected to sell for in an open and competitive market. Letter D, the analysis of past property performance to estimate potential future returns on assessed values. Question number 5. Which of the following best describes the principle of anticipation in real estate? And the answer is letter B, the assessment of a property's value based on expected future benefits and income. Question number 6. True or false? In caveat emptor states, it is the seller's responsibility to disclose all known defects in the property to the buyer. And the answer is false. So in caveat emptor states, typically what's going to happen is it falls on the buyer's shoulders to discover. So caveat emptor, remember, means let the buyer beware. And so in states that really enforce consumer protection laws, then you're going to see that the seller has the responsibility to disclose all known defects in the property to the buyer that they are aware of and encourage inspections. And in caveat emptor states, then the opposite would be true. So the answer to this question was false. Question number 7. Which duty is least likely to apply to an agent's relationship with the customer in real estate? Letter A, loyalty. Letter B, honesty. Letter C, disclosure. Letter D, accounting. Question number 7. Which duty is least likely to apply to an agent's relationship with the customer in real estate? And the answer is letter A, loyalty. And you want to know these fiduciary obligations and responsibilities. These are all going to be on real estate exams all over the place. Some people learn them as old cars. Some people learn them as cold AC. Just remember things like care, obedience, loyalty, disclosure, accounting, and confidentiality, and kind of understand the breakdowns and the basic definitions of each of these, and it will serve you well. Question number 8. The rights of ownership of real property include all of the following except letter A, control. Letter B, possession. Letter C, enjoyment. Letter D, reversion. Question number 8. The rights of ownership of real property include all of the following except. And the answer? Letter D, reversion. All right, so the rights of ownership, control, possession, enjoyment, disposition, exclusion, the right of quiet enjoyment, all of these are the bundle of rights or equitable title, and reversion is not one of the bundles of rights. Question number 9. Which type of deed conveys whatever interest or claim the seller has in the property without warranties? Letter A, special warranty deed. Letter B, bargain and sale deed. Letter C, quitclaim deed. Letter D, general warranty deed. Question number 9. Which type of deed conveys whatever interest or claim the seller has in the property without warranties? And the answer is letter C, quitclaim deed. Okay, so there's a couple of types of deeds that you want to know. You want to know the basic definition of special warranty deed, bargain and sale deed, quitclaim deed, and general warranty deed. Now, the quitclaim deed that we saw in number 9 here is a textbook definition of what a quitclaim deed is. And you also want to know, generally speaking, that the special warranty deed and the general warranty deed are the deeds of conveyance in the majority of states. And the bargain and sale deed is something that some states use for conveyancing and some states use it for less than warranty. So you want to make sure you understand the definitions here. You'll see these in your textbooks. Good luck with your studies. We'll see you in the next one. Question number 10. What is a significant responsibility of property managers concerning property maintenance? Letter A, handling tenant disputes. Letter B, conducting regular property inspections. Letter C, repairing major systems issues at cost. Letter D, negotiating lease agreements. Question number 10. What is the significant responsibility of property managers concerning property maintenance? And the answer is letter B, conducting regular property inspections. Every real estate textbook that you're going to use to study for your exam is going to have some kind of section on property management. And you don't need to know a tremendous amount in that particular unit in most cases, but you do want to know some of the basics, and some of the duties and responsibilities that a property manager has to oversee and conduct are useful to know. There's usually lists inside of books. Just check for those, kind of go through them. You don't have to memorize everything single and just go, oh my God, I need to know all this stuff. Just know the basics, and you will be good to go. Question number 11. What is the acronym often used to remember the fiduciary duties of a real estate agent? Letter A, RESPA. Letter B, old car. Letter C, Pete. Letter D, Kodak. Question number 11. What is the acronym often used to remember the fiduciary duties of a real estate agent? And the answer is letter B. Obedience, loyalty, disclosure, confidentiality, accountability or accounting, and reasonable care. And these are the fiduciary obligations. Another way that some books or modern books might teach them, or different books, is cold AC, which is basically the same thing: care, obedience, loyalty, disclosure, accounting, and confidentiality. So you want to know that there's a couple of different ways that you can do it. No matter what, these are the fiduciary duties. This is the agency chapter or brokerage that you're going to see these inside of. Study these. You definitely want to know them. They do like to throw these on examinations. Question number 12. Which of the following distinguishes negligent misrepresentation from intentional misrepresentation? Letter A, the level of harm caused to the misrepresented party. Letter B, the agent's choice to conceal material defects. Letter C, the amount of false information provided. Letter D, the absence of intent to deceive or conceal material facts. Question number 12. Which of the following distinguishes negligent misrepresentation from intentional misrepresentation? And the answer is letter D, the absence of intent to deceive or conceal material facts. So you definitely want to know the difference between negligent misrepresentation and intentional misrepresentation. Many books have kind of these lists or scenario examples. This might be a scenario-based question, by the way. They might give you sort of like frame out something and kind of put something in there, like was there intent to deceive or conceal or not? And was it a mistake or was it this intentional act? Okay, so you want to know those. Another good question. We'll see in the next one. Question number 13. What key elements are typically found in a rental agreement or lease? Letter A, tenant's pre-approval of funds from a lender. Letter B, the names and contact information of both parties, property description, and rent due. Letter C, a list of any fees and expenses due from the tenant. Letter D, both B and C. Question number 13. What key elements are typically found in a rental agreement or lease? And the answer is letter D, both B and C. Okay, so a list of any fees and expenses due from the tenant, and the names and contact information of both parties, property descriptions, and the rent due. Obviously, the tenant's pre-approval of funds from a lender, they're not borrowing money for a lease necessarily, or typically, unless it's some sort of commercial lease, obviously. So there could be something there, but this isn't. This is dealing with residential. So there's the pre-approval of funds. That's kind of something that's a little more obtuse, and therefore I would have picked B and C. Question number 14. What is the primary purpose of the statute of frauds in real estate contracts? Letter A, to ensure contracts are fair and equitable. Letter B, to require all contracts to be in writing. Letter C, to prevent disputes arising from oral agreements. Letter D, to promote transparency in contract negotiations. Question number 14. What is the primary purpose of the statute of frauds in real estate contracts? And the answer is letter C, to prevent disputes from arising from oral agreements. So the statute of frauds generally requires that certain types of contracts be in writing in order to be enforceable in a court of law. So, or between the parties, but it's really between the court and the other parties to figure out if this thing is legit and can be enforced. So oftentimes we will want to see many types of contracts in writing in order to be enforceable in the courts. And that's what the statute of frauds really is all about. Question number 15. Maria is looking for a financing option where she can borrow against her home's equity as needed with variable interest rates similar to a credit card. What should she consider? Letter A, a construction loan. Letter B, a bridge loan. Letter C, a home equity loan. Letter D, a home equity line of credit. Question number 15. Maria is looking for a financing option where she can borrow against her home's equity as needed, have a variable interest rate, and it's similar to a credit card. What should she consider? And the answer is letter D, a home equity line of credit, many times on exams or in books reflected as simply HELOC, which is the acronym, home equity line of credit. And this is a fairly textbook definition of that. You want to know these in the financing section of most of your real estate books. You're going to find the mortgage section, and inside of that, this type of loan is known as a HELOC. Question number 16. What is the advantage of adjustable rate mortgages? Letter A, fixed interest rate throughout the loan term. Letter B, lower initial interest rates compared to fixed rate loans. Letter C, predictable monthly payments through loan maturity. Letter D, all of the above. Question number 16. What is an advantage of adjustable rate mortgages? And the answer is letter B, lower initial interest rates compared to fixed rate loans. Question number 17. Which approach is most suitable for estimating the value of unique or specialized properties? Letter A, sales comparison approach. Letter B, cost approach. Letter C, income analysis approach. Letter D, comparative market analysis. Question number 17. Which approach is most suitable for estimating the value of unique or specialized properties? And the answer is letter B, the cost approach. So remember, the cost approach to value has two sort of subcategories. One is replacement cost and one is reproduction costs. And typically when you're looking at figuring out unique or specialized properties, we can use the cost approach. A lot of appraisers don't necessarily subscribe to the cost approach unless you have a unique situation or specialized property. Typically, they're looking at the market, and that's when the sales comparison approach carries the most weight in residential property valuation. And then if it's an income-generating property, then we look to the income analysis or the income approach. Now, the comparative market analysis, or the CMA, is what real estate professionals use to determine what the price or cost or sales price of a listing could be when they're doing sort of this valuation touch-up when it comes down to clients. And so the cost approach is for specialized or unique properties. Question number 18. Which of the following is not encompassed by fair housing guidelines? Letter A, non-discriminatory advertising. Letter B, reasonable accommodations for applicants and tenants with disabilities. Letter C, fair treatment of all potential applicants. Letter D, implementing policies to discriminate against certain protected classes. Question number 18. Which of the following is not encompassed by the Fair Housing Guidelines? And the answer is letter D, implementing policies to discriminate against certain protected classes. These are one of those question types that kind of give you a weird jumbling of phrases in sentences, and you have to read them very, very carefully in order to determine what's happening. And this is one of those where three are going to be similar and sort of in theme thematically with each other, and then one will be the outlier. And that's kind of the one that they did there. So, which is not encompassed by fair housing guidelines. In other words, which is something that doesn't stand for what the fair housing guidelines do stand for. And letters A, B, and C all happen to stand. So non-discriminatory advertising, yep, that the fair housing stands for that. Reasonable accommodations, yep, the fair housing stands for that. And fair treatment of all potential applicants, yep. So A, B, and C are all yeses. And then the not encompassed by, that could be a little weird to a reader. But, again, I submit to you that a lot of times test writers write weird questions. Implementing policies to discriminate against certain protected classes. Well, the fair housing is anti-discrimination. So this letter D is saying, hey, we're writing policies to discriminate, and therefore that's why it's the outlier. Okay, so letter D here was the answer. Question number 19. In a title theory mortgage, who retains legal ownership of the property until the debt is repaid? Letter A, the borrower. Letter B, the vendor. Letter C, the title company. Letter D, the lender. Question number 19. In a title theory mortgage, who retains legal ownership of the property until the debt is repaid? And the answer is letter D, the lender. So the lender in this particular instance is who retains title in title theory states. In lien theory states, the consumer has equitable title. And then in a title theory state, they create a deed of trust scenario. And you'll learn about those phrases inside of your text, typically inside of the mortgage finance sections. You'll look at lien theory versus title theory, and that's sort of what you're looking up there. Question number 20. The legal process through which ownership of property reverts to the government when the property owner passes away without a valid will and no rightful heirs or beneficiaries is called? Letter A, intestate. Letter B, testate. Letter C, escheat. Letter D, probate. Question number 20. The legal process through which the ownership of property reverts to the government when the property owner passes away without a valid will and no rightful heirs or beneficiaries is called? The answer? Letter C, escheat. So remember, escheat is the legal process, and this is textbook definition. So this is a pretty good definition for what escheat happens to be. There's going to be variations throughout different books and different test writers, etc. Now, intestate, testate, and probate are all vocab phrases in addition to escheat. So you want to go through a question like this and go, okay, what does intestate mean? Well, intestate means no will. So a piece of this definition. Testate means I died with a will. And then probate is the legal process through which the court systems reconciled the deceased's assets. So we want to know all of these vocab phrases, but escheat here was definitely the standout. Question number 21. Which of the following is not a fiduciary duty that an agent owes to a client from the old CAR acronym? Letter A, loyalty. Letter B, consideration. Letter C, obedience. Letter D, disclosure. Question number 21. Which of the following is not a fiduciary duty that an agent owes to a client from the old CAR acronym? And the answer is letter B, consideration. All right, so consideration is something that you learned in contracts, and loyalty, obedience, and disclosure all fit within the acronym old CAR. Remember, sometimes they might do old CAR, and sometimes they might do cold AC. No matter what, either way, these are all fiduciary duties that an agent owes. This is going to be in the agency section in your books, and consideration is in the contracts section of your book. Question number 22. The act of the government exercising its right to take private property for public use is called? Letter A, conversion. Letter B, eminent domain. Letter C, escheat. Letter D, condemnation. Question number 22. The act of the government exercising its right to take private property for public use is called? And the answer is letter D, condemnation. So you want to know eminent domain and condemnation and sort of how they work together. Eminent domain is the right, condemnation is the process. And this one said the act of the government exercising its right. The right in this particular question is B, eminent domain. And so the act of exercising its right is condemnation. This is the process or the act of exercising. So you want to know the difference, the distinction between B and D, and you want to know this. This is on examinations. This is something you're definitely going to see. Test writers like to jumble this one up. They like to confuse people. It's a good one for people to write about. So every real estate book all over the place is going to reference this. Be careful. Watch out for this one. I've gone through this one so many times because I know it's on there, and I hope you all get it. Talk to you soon. Question number 23. What is the highest form of property ownership that grants the owner complete and unrestricted ownership rights? Letter A, fee simple absolute. Letter B, fee simple defeasible. Letter C, fee simple condition subsequent. Letter D, leasehold estate. Question number 23. What is the highest form of property ownership that grants the owner complete and unrestricted ownership rights? And the answer is letter A, fee simple absolute. Okay, all of this here is interests in real property. All of these here are real legitimate vocab phrases. And the phrase fee simple absolute, this is pretty classic definition for that. Fee simple defeasible has some kind of restriction. So versus unrestricted in this question, fee simple defeasible is something with restrictions like deed restrictions. Fee simple condition subsequent is also something with restrictions. It's a different type of subcategory of defeasible fee estate. And a leasehold estate is like, a lease, renting property. So leasehold estates have some restrictions, right? It doesn't grant the owner complete and unrestricted ownership because they're still subject of interests that exist in the asset. So you want to know fee simple absolute, and you're going to see something like this pretty good on exams. Question number 24. Emblements are considered to be letter A, real property. Letter B, trade fixtures. Letter C, personal property. Letter D, improvements. Question number 24. Emblements are considered to be the answer. Letter C, personal property. Okay, emblements are personal property. This is very classic real estate and the law, real property and the law style sections in textbooks. You're going to find it there. You want to know personal property is also called personalty. You definitely want to know what trade fixtures are and sort of the rules and regulations of trade fixtures and when they're abandoned, whatnot. Real property is also called realty, and then improvements is another minor vocab phrase that you many times see on those sections to kind of throw students off. Many times they don't really call out improvements, but they will call out personal property, trade fixtures, and real property. So look out for all of those. Let's go to the next one. Question number 25. The act of transferring or conveying ownership rights or interests in a property from one party to another is known as letter A, alienation. Letter B, accretion. Letter C, conversion. Letter D, estoppel. Question number 25. The act of transferring or conveying ownership rights or interests in a property from one party to another is known as, and the answer is letter A, alienation. Okay, so you want to definitely know the phrase alienation means to transfer or convey, and therefore we have alienation clauses inside of mortgage documents, and you learn that phrase as a mortgage clause. It means, in other words, if you transfer ownership, then you're going to have to pay back the lender. That's what an alienation clause is, also known as a due on sale clause. So you see this phrase alienation inside of like the deeds unit, and then you'll see it inside of the mortgage financing unit where they're talking about the alienation clause or the due on sale clause. Excellent. All of these are legit things like accretion is something, conversion is something, and estoppel is something. So you want to know these all. These are all vocab phrases. Look to our vocabulary flashcards, in our channel, and they'll help you out as well because we do cover all of these. Question number 26. What is the main difference between legal title and equitable title to real property? Letter A. Legal title is based on possession, while equitable title is based on ownership. Letter B. Legal title can be transferred voluntarily and equitable title cannot. Letter C. Legal title is always absolute and irrefutable. Letter D. Legal title is actual ownership rights. Equitable title is contractual interest. Question number 26. What is the main difference between legal title and equitable title to real property? And the answer? Letter D. Legal title is actual ownership rights, and equitable title is a contractual interest. Equitable title is also the future right to own, and legal title is the actual ownership. And many times they frame out in synchronicity. But if you look at different things, we can distribute these differently. Like in land contracts, we distribute this differently. Vendor, vendee, each one gets legal title versus equitable title. When you're looking at a trust is a vehicle that actually looks at this concept and splits it up. We split up legal title held by a trustee for the benefit of a third party. The trustees are benefiting the beneficiaries, and the beneficiaries have equitable title. So again, you're going to see this concept used through and throughout. Very powerful concept. You want to know what is legal title and what is equitable title and the difference between the two. This is a good question. Question number 27. The defining characteristic of a defeasible fee simple estate is that, letter A, it can never be terminated or revoked. Letter B, it must be passed on to one's heirs. Letter C, it can be terminated under certain specified conditions. Letter D, it provides unlimited ownership rights. Question number 27. The defining characteristic of a defeasible fee simple estate is that it... And the answer? Letter C, it can be terminated under specified conditions. Remember, in defeasible fee estates, those are restricted, not unrestricted, whereas like the fee simple absolute was unrestricted. And therefore, the defeasible fee estates are like on a condition subsequent and determinable, which means they can be terminated. If you mess something up in sort of the requirements, then the ownership can transfer back to the restrictor of the estate. So it can be terminated under specified conditions, certain specified conditions. Now, letter A, B, and D all reflect sort of the fee simple absolute. So you really need to know the difference here between fee simple absolute and fee simple defeasible. Many times they call fee simple absolute fee simple indefeasible, as a matter of fact. And that's another vocab phrase that you'll see sometimes be slipped in. So they want you to know that, but many times book authors don't write in that phrase. They call it fee simple absolute. And irritatingly enough, they should simply also call it fee simple absolute equals fee simple indefeasible. And therefore you can see the difference or the distinction between defeasible and indefeasible. But letters A, B, and D are all about fee simple indefeasible, and letter C is all about fee simple defeasible. Question number 28. Which of the following terms is not included in the real estate acronym PITI? Letter A, principal. Letter B, income. Letter C, taxes. Letter D, insurance. Question number 28. In which of the following terms is not included in the real estate acronym PITI? And the answer is letter B, income. So PITI stands for principal, interest, taxes, and insurance. And this is a pretty easy one. There are several acronyms that you want to memorize. This is one of them, and you're going to definitely see this inside of the mortgage finance section and sort of what are the breakdown of the payments of a mortgage. Okay. Question number 29. Which type of ownership is specifically designed for married couples and offers legal protection against individual debts? Letter A, joint tenancy. Letter B, tenancy in common. Letter C, tenancy by the entirety. Letter D, community property ownership. Question number 29. Which type of ownership is specifically designed for married couples and offers legal protection against individual debts? The answer? Letter C, tenancy by the entirety. Okay, all of these are real things, so you want to know all of the definitions here, and this is a pretty good definition of what a tenancy by the entirety is. A tenancy by the entirety is for married couples. So you want to know that, and you also want to know that it's the right of survivorship, and it's one of those types of ownerships that offer legal protection against individual debts. Question number 30. What is the determining factor for classifying an item as a fixture or personal property? Letter A, its value. Letter B, its size and location. Letter C, its intention of permanence. Letter D, its function. Question number 30. What is the determining factor for classifying an item as a fixture or personal property? And the answer, letter C, its intention of permanence. Fixtures and personal property and the differences and things like emblements and things like the requirements of what is a fixture and trade fixtures are all in the real property and the law types of sections on real estate books. Check them out. You'll find them there in the books that you're studying. And this is its intention of permanence is of paramount interest to the courts, especially when they're trying to determine if this thing should be considered a fixture or it should be considered personal property. Hey, thanks for tuning in. I hope these questions were useful and helpful, and some of my analysis of the questions are going to be useful for you when you are studying for this examination. Thank you so much for tuning in and checking out our content. I hope it truly is helping y'all pass and understand things a little bit better. If you found some value in this, check out some of our other videos. Our channel has a ton of different formats and different types of training. Check them out and let us know what you think. We love the comments. We love to hear folks are passing. We love all of that stuff. Make sure to subscribe to our channel for updates and information as you're studying, and if you like it, pass it on to friends and stuff, so let them know that we exist. It'd be awesome and very helpful to us. And again, we appreciate you, and we will see you in the next one.